We will reconvene meeting number 62, and we will go to agenda item number 7, discussion about Region C. And we're going to start off with Commissioner McHugh just trying to give us sort of a background status report, and we will take it from there.
Okay, Mr. Chairman. So this is designed, this little presentation is designed simply to bring us, try and consolidate some of the variables that we've discussed with respect to Region C over the last few months, and it's designed just to be a discussion starter so we can all be essentially on the same page. The piece of paper I just handed to you simply has, and I'll come back to that in a second, and we'll post it on the web as part of the meeting. It simply has the text of Section 91 of the expanded gaming statute, statutes 2011, Chapter 194, and then it has below it Section 2.6 of the compact, just those two things quoted verbatim. And I'll talk a little bit more about those as we get deeper into this. But there are four principal issues that we need to think about, or should think about, among others, as we think about Region C. The status of the tribal project, of course, is the first. The land and trust application, the current litigation involving AG Urban, and then commercial RFP considerations. Those are the, at least it seemed to me, the four main topics on which we ought to focus as we think about what, if anything, to do about Region C at the present time. So we start, I'm going to start with the status of the tribal project and go through each of those issues seriatim. The compact, as we know, has been executed. The new compact has been executed. It's been sent to the legislature by the governor. It's now in the joint Committee on on Technology and Economic Development. It will be reported out of that committee at some point. There'll be hearings, no doubt, but we don't have any indication as to when that's likely to happen. It's not going to be a long way away, but we have no date for that. Thereafter, the approval of the compact by the BIA, the Bureau of Indian Affairs, a branch of the Department of the Interior, is necessary. Before it can be sent to the BIA, the legislature has to approve it. Approval by the BIA, according to the tribe, seems likely. We do know from a conversation that I had with Assistant Secretary Washburn, who's the head of the Bureau of Indian Affairs, that the BIA this time gave both the tribe and the state some technical assistance on parts of the contract that they requested, the compact that they requested help with. So that is a factor to take into account in thinking about the likely approval. And the BIA has 45 days from submission to act, approve or disapprove. So it's not unreasonable, I think, to suspect that that action will take place sometime over the summer. I've just put mid-August up there as a reasonable date. I have no information that would lead me to say that's the date, but just thinking things through, that's probably a date when we can expect some action. The project status, insofar as the project itself is concerned, is as follows. These are the highlights. There's more to it. It's all available on the City of Taunton website. They've done a good job of putting up the various components of this. The site, of course, has been identified. The voters approved tribal gaming at that site on June 9. There was a referendum in Taunton, and they approved it on June 9, 2012. There's an intergovernmental agreement between the tribe and the city that was signed a month later on July 10 of 2012, and that, of course, is analogous to the host community agreement. The order was a little different, but of course they're not governed by the statutory process. And then the tribe paid the city 1.5 million, which was a specified mitigation fee, in mid-August of 2012. A MEPA, an ENF certificate was issued by the Secretary of Energy and Environmental Affairs on August 24, and it stated that the tribe was required to prepare a draft environmental impact report. Since then, a number of studies have been done, and one assumes that that process is moving forward smartly. There is the MEPA process, which is the state process, and then there's the NEPA process, which is the federal process, and the interrelationship between them is somewhat complicated, but the MEPA process presumably will govern the land in trust site that needs to be dealt with in order to make the project succeed after the property is taken into trust, if it is. And the NEPA process will deal with the site itself as well as some of the surrounding areas. But both processes seem to be moving forward in parallel. The initial, on the Bureau of Indian Affairs front, the initial reservation determination was approved on February 17 of this year, just last month, or a month and a half ago. That is an approval that's necessary under a statute that says that after a date in 1988, tribal lands can only be used for gambling if they were taken into trust, if there were certain federal exceptions apply, and the BIA concluded that the exception, the initial reservation exception, applied to the tribe, so they've gotten that approval. That only matters if the land is taken into trust ultimately, but at least it's another piece that they have, another step that they've accomplished. So the final decision on taking the land into trust, if one looks at these details, is the big step that has yet to be taken and yet to be done. And an outcome favorable to the tribe, I submit, is unclear at best. And even if it is favorable, the timing of it is, at this point, very difficult to determine, but it's unlikely to come soon, I think, because there are several issues. The first of them is the Carcieri decision, and that is the trickiest and the largest hurdle. The Carcieri decision refers to a Supreme Court of the United States decision in 2008 that interpreted the statute that deals with when the Secretary of the Interior can take land into trust. And the court in that decision, the majority, it was a 6-3 decision, so it's not a one-vote changer, said that land may be taken into trust only for a recognized tribe that was under federal jurisdiction, and that's a term that has some implications, in June of 1934 when the statute was passed. There's no question that this tribe, the Mashpee Wampanoags, is recognized. The under federal jurisdiction piece, though, is much more difficult issue. There is no definitive federal decision that defines what that phrase means. And whatever it means, it will require a really fact-intensive determination. In 2010, in a decision involving the Cowlitz tribe from the state of Washington, the Bureau of Indian Affairs took land into trust, and in addressing Carcieri, it said that the under federal jurisdiction inquiry was a two-part inquiry. And the first, and I think it's worth quoting in this, it's worth quoting. The first question said, the Bureau in that case, is to examine whether there was sufficient showing in the tribe's history at or before 1934 that it was under federal jurisdiction, i.e. whether the United States had in 1934, at some point in the tribe's history prior to 1934, taken an action or series of actions through a course of dealings or other relevant acts for or on behalf of the tribe, or in some instances, tribal members, that are sufficient to establish or that generally reflect federal obligations, duties, responsibility for or authority over the tribe by the federal government. So it's an historical inquiry to see whether any of those criteria, none of which is, has sharp edges, I submit, existed in 1934 or earlier. And if the answer to that is yes, there is some indication, some showing that the tribe was under federal jurisdiction before 1934. Was it under jurisdiction, under federal jurisdiction in 1934? That's how the BIA defined the term in the Cowlitz decision. Cowlitz has been challenged. It's in litigation now, has been since January 31, 2011, in the Federal District Court in Washington, D.C., I believe, and is in various procedural stages there, with no decision yet on the merits. The Bureau in this case is at work. It's taken other land into trust since Carcieri was decided, and the Carcieri analysis is now a top priority for the BIA solicitor, Hillary Tompkins, according to a letter she sent recently to the tribe, so that's being actively investigated by the solicitor's office. However, in that same letter, Ms. Tompkins stated that the majority of the Carcieri determinations require a comprehensive, fact-intensive analysis that can be time-intensive and costly. Take a long time, cost a lot of money, is basically what that says. She continued by saying that the Office of the Solicitor is committed to giving this a top priority, but she gave no estimate of when she would be finished. In addition to that, her determination will take the form of advice to the Assistant Secretary for Indian Affairs. It will not be a separately announced finding. And so the Secretary then will consider her advice and make a judgment as to whether to accept it, whether to reject it, whether to seek modification, whether to seek more information. It's ultimately his determination and not her independent determination. There have been a number of legislative efforts to fix the Carcieri decision. The legislature, the Congress can fix it, change the statute, because it's a statutory interpretation. It's not a constitutional interpretation. So on a going forward basis, at least, the Congress can fix it. Those have not succeeded, and one can only say that at this point, it's unlikely that there will be a fix. And we ourselves have no independent basis for making the under federal jurisdiction issue. We just don't have the wherewithal, we don't have the tools, we don't have the know-how, the background, or the expertise, I think, to make that determination, but that's something we can talk about. The second issue is the NEPA process. It has to be completed before the trust decision is made. The process has started. The tribe predicts that it will be completed in early 2014. We had some independent discussions with the EPA, who said that the tribe's estimate was within the range of reason. It was doable. No guarantees. The EPA is not conducting the process. It has the status of a commentator, not a decision maker. But they've been around the block a few times, so their assessment that it's within the range of reason is worth something. Kevin Washburn, the Assistant Secretary of Affairs, Secretary for Indian Affairs, as I've mentioned, has simply said that it takes time. In my conversation with him, he did not give an estimate as to when it would be completed, nor did he give an estimate of how long it would take. He simply said it takes time. These are complicated. The record in other cases suggests that the entire land and trust process, including the NEPA component, has taken years to conclude. And that is not an aberrational, those cases in which it's taken years to conclude do not appear to be aberrational. The next issue, the third issue, is post-decision litigation. Litigation is likely, it seems, given the nature of the decision that has to be made and the intensity one can feel as to some of the issues that have surfaced thus far. Litigation is likely over the Carcieri decision and whether the Bureau has the power to take the land into trust. And then the merits. The merits, inevitably, for those who are opposed to a favorable BIA decision, the merits are likely, inevitably, going to be fact-intensive. There's going to be ground for challenge, not necessarily a successful challenge, but there's going to be ground for challenge. And that could be both time-consuming and expensive as well. A June 2013 Supreme Court decision in a case called Salazar against Pacek broadened the class of people who had the right to challenge a BAA determination to take land into trust, and had the effect of giving challengers 6 years to do so. So that's 6 years from the time the decision, the BIA decision is made. The BIA, because of that decision, as I understand it, no longer will postpone the effective date of its land and trust decision.
Which is in effect what it did in Cowlitz?
It did not do it in Cowlitz, because Cowlitz was a that's right, it did not postpone the effective date of that. It used to, as I understand it, postpone the effective date because it was believed that people who were to bring suit only had 30 days to do so. So it would for some reason, that led them to postpone the effective date of the decision. It's my understanding they no longer are going to do that while litigation is pending. It's possible that an injunction could postpone the effective date of it. But it is difficult to predict whether an injunction would issue, because an injunction is always discretionary on the part of the judge who's hearing the case and depends on a showing of irreparable harm. And one will really have to take a look at the circumstances as they then existed to see whether a showing of irreparable harm could be made, and whether the other factors necessary for a preliminary injunctive relief could be made. It's just very difficult to predict whether that could happen. But it is predictable that if litigation does occur, it would take several years. I've said 4. There's no magic to that. To conclude, think about about 2 years, 2.5 years in the trial court, and another 18 months to get through an appeal to the First Circuit, assuming this were brought in as it likely would be in the federal district court. Longer if this were the first case to effectively raise the under federal jurisdiction issue and the Supreme Court were interested in revisiting that Carcieri case or expanding on and explaining the meaning of the phrase. Then you could add more time to that if the Supreme Court took it. But I think about 4 years would be a good estimate of how long it would take without that. So that really is the status of, as I see it, those are at least the factors in thinking about where the process is. The other factor that has to be considered is the KG Urban litigation. I don't want to get too far into that because it's not necessary to do so, but it's now, as we know, pending in the First Circuit, pending in the district court after a remand from the First Circuit. And the importance of this is that the First Circuit decision may limit the amount of time that the commission is permitted simply to do nothing. The First Circuit decision said, in effect, that it is okay to freeze Region C to commercial applications, but only for the period necessary necessary to support the Indian gaming legislation, and let that work its way through an appropriate process. And that the longer the freeze remains in place, particularly without a defined end date, the less likely the court will be to consider the freeze as a temporary support for the IGRA process, the Indian gaming process, and the more likely it will be to view the process, view the freeze as a race-based preferential set-aside that would be subject to something called strict scrutiny, which rarely allows the legislation or the administrative act to survive. KG Urban's case basically is a 14th Amendment equal protection case. It's other things as well, but that's the core of it, based on what KG Urban claims is an impermissible racial preference for a tribal casino. So that's another piece that's in the mix. If we turn to the idea of a commercial RFP in Region C, we are, the issue there is Section 91 of the Expanded Gaming Act, and that's why I've circulated the text, because this is an issue that we've discussed on a number of occasions, but it's one that we really need to think about with precision here, because there is, I think, a misunderstanding of exactly what is stated where. The first relevant portion of Section 91 is Section 91E. And 91E says, and I'm paraphrasing here, you have the text in front of you, and as I say for others who are watching and listening, it'll be up, this little sheet with the text will be up on our website when we finish all of this. Section 91E says that the commission must issue applications for Region C commercial licenses if there's no signed compact approved by the legislature by July 31, 2012, condition 1, or if the commission determines that the BIA will not take land into trust. So if either of those two things happens, then the commission must issue a commercial RFP in Region C. The section does not prohibit, there's nothing in that section that prohibits the commission from issuing an RFP for commercial licenses at any time. There's no prohibition in the statute. There's no prohibition in the text. The commission is not barred by the text of the statute from issuing a commercial license.
If I could just add to that, that's it's our interpretation as our lawyers read it. If I understand that, that's also the advice we've gotten from the Attorney General, the way that office reads it.
We've not gotten any formal advice from the Attorney General.
Okay. But we have done our best to get legislative intent clarified on this, and the clear statement from the various drafters in the legislature was that this is the accurate reading of the law.
Yes, that's so, and it also is faithful to the text of the law, and so we have that. Now, there was in the last compact, and there is in this compact a provision, a number of sections that are replete with sections. It's a long document, carefully thought out, carefully negotiated. Paragraph 2.6 of the current and former compact interprets Section 91E as stating that, and I'm quoting, "The Commission will not issue," close quote, "a commercial RFP in Region C unless it determines that the BIA will not take land into trust." That is not what Section 91E says. 91E says what I just said it says. But the compact says that it says something different. So the question there becomes whether a contract, basically negotiated between the governor and the tribe and approved by the legislature, as the last one was, can alter statutory language that says something different than the contract says. That is an issue that I'm not aware has ever arisen before, but it strikes me as unlikely that it can do so. But there you are. That's what it says. That's how it got there. The revenue portions of both compacts expressly contemplate the Commission's issuance of an RFP for Region C and decrease the Commonwealth's share of tribal gaming revenues if it does so. So structurally, the compact has built into it a remedy or a concession fee or concession fee schedule, basically, that kicks in if the Commission does what, if the Commission issues a commercial RFP. And it also gives the tribe, in the event that the Commission issues a RFP for a Category 1 casino and grants a license, the right to terminate the compact entirely and proceed without it. The tribe could also bid and become a commercial applicant. So the tribe would have a number of options if the Commission opened Region C for commercial activity. The next issue, that's about all I have to say about the compact and its relationship to the statute as a discussion starter piece. Insofar as a commercial RFP is concerned, then another issue to consider is a timetable. If we use for Region C the timetable that we have used for Regions A and B and adjust for the delayed start, the timetable would look, I think, something like this. We'd issue an RFP for Phase 1. The deadline, I mean, for submitting RFP Phase 1 applications would be August of this year. The suitability determinations would be concluded by May of next year. The Phase 2 deadline would be a year from this August, August of 2014, and a licensing decision would come in December of 2014. Now, that is, it's better than throwing darts against a dartboard, but that would parallel what we've done. I think we could improve on that schedule, but that's a starting point.
Commissioner.
Yeah.
Could I go back, could we go back to the prior slide, I believe slide number 10? I just want to make sure we make this distinction. This is something that I just begun to realize the difference. I guess I always assumed that
This one?
the revenue
Commissioner?
projections, yeah, the last sub-bullet at the very bottom,
Right.
that the revenue projections would change in the manner that they do with the award of a license.
Right.
Not the issuance of an RFP.
Yes, I misspoke if I said otherwise.
Okay.
They change when the license is awarded.
When the license is awarded.
Right.
Thank you.
And they change from, under the current structure, if the tribe is the only Category 1 full-fledged casino in the state, they pay 21% of revenues, gross gaming revenues to the Commonwealth. If there's another casino someplace in the state, it's 17%. And if there's a casino in Region C, it's 0. And if there's a slots parlor in Region C, either the 21% or the 17% drops down by 2%. That's the structure now.
Just for the record, actually, if you look at that bullet point, it is miswritten. It says Commission's issuance of a commercial RFP, and it should say commercial license.
Commercial license.
Yeah.
Yep, sorry.
So that's fine.
That's right.
No.
Yep, that's right. So we'll correct that in the version that's posted on our website. That's an important difference.
Yeah, thank you.
Just going back a little bit earlier than I guess. You talked about the Patrick decision. I think you
Yeah, that's
referenced
another
the
typo,
June
too.
2013 decision,
Correct.
slide 8.
Must be a more elegant way to do this, but,
June 2012, is that what you mean?
2012, you're right. Yeah, another typo, another mistake. Right.
I didn't know if you had any insight to what the Supreme Court was deciding, or,
Well,
He's practically the
I'm
Pope,
inside
you ought to be
info.
able to know what the Supreme Court is doing.
right.
Jim, the commissioner's packet's already on the web, but we can switch it out.
So we'll switch it back, yeah.
Was that decision Salazar, or was that the Potawatomi Indians versus Patchan?
It's known as Salazar against, I mean, that's the short.
It's what-
I think he was another party to that
Representative.
case. Okay, so with those corrections and amplifications, those are some background considerations. And now, the question is, or questions for discussion include these. What happens, or what are some of the issues that may arise if the commission waits for more clarity before it issues or decides not to issue permanently a commercial RFP in Region C? And the first is obvious. There's likely that there'll be no construction or gaming revenue in Region C for a considerable period of time, though the length is impossible to determine with the information we have now. It's gonna be some period of time, and at best estimates, look like it will be considerable without, but there's no way to tell when. If the land and trust decision is negative at the end of that period, then the commission will have to begin a commercial process, perhaps years after licenses have been awarded in regions A and B, leaving a part of the state that's really been hit by the economic downturn without the revenue stream that these casinos are providing to other regions. And if the land in trust decision is positive, the commission will face not only a revenue stream 8 to 10% less than the revenue stream from the commercial casinos, but also a revenue stream that could start considerably later. So you lose the time, the money over time, and Commissioner Zuniga is going to talk to us a little bit about that in a minute. So those are some, I think, obvious consequences of waiting. If we proceed now to issue a commercial RFP in Region C, the tribe could elect to pursue it without abandoning its land in trust application. They could pursue both simultaneously. There's no reason why they couldn't. They could be a commercial applicant as well as pursuing the land in trust theory. If it doesn't elect to pursue a commercial license, or if it applies and is the unsuccessful bidder for a commercial license, it's possible that the land and trust application will be successful, and that Region C will then have 2 casinos operating, one of which will have a much lower overhead because its gaming revenues will be untaxed. If there are 2, the tribe pays the state nothing. The tribe could also disavow the compact and operate Class 2 gaming at least, which is essentially a slots parlor. It's more than that, but it's essentially a slots parlor, without any Commonwealth participation or oversight. And so those are the consequences, potential consequences of proceeding now. We proceed without knowing the outcome of the tribal process and without the applicants knowing the outcome of the tribal process, and so that could be a consequence. Financial considerations, I just wanted to state the questions, and then Commissioner Zuniga is going to talk about them, and this is really picking up on the second, what happens if we proceed now, the theory. Would a commercial casino be viable in the same region as an untaxed tribal casino? what kind of rate of return would be required for an investor to take account of the risk of that kind of competition, and would that necessary rate of return make the entity a viable entity? What kind of a market share would the commercial casino require in Regency in order to yield to the Commonwealth tax revenues equal to the 15 to 17% that a tribal casino would yield if it were operating exclusively in that region? And then what kind of revenues would be needed to account for the absence of any revenue between now and the time the dust settles? So that may be a good segue to turn that over to you, Commissioner.
Sure. As I was contemplating this from a purely financial standpoint, I started with the question of timing, because as we contemplate timing, there's a direct question in my mind financially on timing. And although I don't have slides to guide the discussion, I can perhaps tease it out conceptually, and we can discuss more details. But because the compact sets forth a lower rate than a commercial license, one way to look at this would be how sooner or when would the Indian operation have to be compared to a commercial license. And we can go back to the slide that has a tentative time of a commercial request for the Commonwealth to be indifferent. There's the difference of 8 to 10%, which is significant. But there's also the difference of $85 million upfront that comes to the Commonwealth in the form of the licensing fee. That does not come when we are contemplating an Indian, the tribal operation. So if you factor those two differences and make some projections, the reality is that, and brings at some discount rate to today, between the two options, the reality is that for the Commonwealth to be neutral under those two scenarios, the tribal operation would have to be up and running significantly earlier than that. And but I want to say, let's put that aside for a little bit, because that is really not the choice. The choice is the one that you finished with, which is waiting for one tribal operation for some period of time, and we can talk about timeline there, or requesting issuing an RFP for a commercial license with the real probability that sometime in the future that commercial license has competition in the region by virtue of how the tribal operation reacts to that. Whether they don't respond to the commercial RFP, or whether they respond and are not awarded, and whether they go further with and conduct on their own right, by their own right, Class 2 gaming. So that's really what we should be contemplating, and the way you finish those slides. If those are the two scenarios, the first point in slide number 15, Commissioner, if you don't mind, taking us back there. Is a very important one, and I would further make the point within here, which is the risk evaluation will have to be made by the operator relative to
By the commercial operator.
By the commercial operator. It would depend on how far away they may or may not be with another operator, whether they can, by virtue of whatever it takes the tribe, whatever time it takes the tribe, whether they can enjoy a lengthy or a short period of exclusivity, which may give them an advantage. It really dovetails into the notion of capturing market share in that context. But it is reasonable to assume that a commercial bidder could or would have to make provisions for seeing some outer year cash flows decrease in some manner, potentially. I think they are the ones in best suited to make those calculations. But the point here is important, also highlighted in the second bullet. They will likely demand that out of their internal rate of return, and they would have to consider the minimum investment amount that is set forth as per our regulations. I don't have an answer. We of course don't have an answer, but
Right.
that's certainly a topic for discussion. I think the key point there is this commission or this state cannot really know unless it bid out that commercial license. Cannot really know that internal rate of return, those assumptions behind future cash flows, the certainty behind or the sensitivity analysis behind the future cash flows. All of this is conjecturing at this point. If and only this commission bid out this region, the only way to really gain more information to that effect is by seeing what a proponent or proponents would put forward. I can talk about a little bit more about any of these, but I'll go talk a little bit about the third bullet as well, which is a very important and is, I think, a very important point, and I think it's at the crux of many of the comments we heard a week ago when we were in Fall River. And I would term it as an opportunity cost. And there are a number of opportunity costs in this decision that we face. They're the ones that I would say are more direct. The foregone revenue, the revenue that doesn't come in because there's time that passes now and continues to drag. There's those that are also direct, less able to estimate, but are very important, and those are the jobs, which I think are also very important. But there are other costs that I would submit are very hard to quantify in the conversation of opportunity costs. That could be substantial. If a project like this, and we heard this last week, ends up being the catalyst for, say, certain pieces of economic development, like the rail down to that region, rail expansions or other factors like that. And this catalyst doesn't come to fruition, that's a significant opportunity cost. Again, it's very hard to estimate. I could only phrase them as significant. Those were the main points that I wanted to make relative to the distinction. I think relative to this discussion, rather, I think when I was talking to one of our consultants relative to the financial aspect of this, they were bringing up the point, I think appropriately, that the main decision for a commercial bidder would have to be relative to meeting, and for the commission, relative to whether they can appropriately meet the minimum investment required satisfy the rate of return that they would demand with the risk, for the risk that they would take, because they would be taking the risk of some uncertainty about how much time they would be able to enjoy in terms of exclusivity. Because what gives real value to these licenses is enjoying a sphere of geographical exclusivity, which is how this legislation was put forth to begin with.
Do we know that that's accurate? That's, you got that information from our, one of our consultants, correct?
That's correct. That's correct.
Do we know that what's accurate?
That exclusivity is worth so much. I mean, if you look at the Pennsylvania experience, they have casinos within 30 minutes of one another doing extremely well, extremely well. Better than the projections were for them to do. So I just sometimes wonder if that is worth all, if there's a way to project that accurately.
Well, there is, and that's an important point, because they have not done something that can be done, which is in the end an estimation, but to draw what they term gravity models, to see within, depending on the site of a casino, to look at a bubble that's normally within 1 hour drive time, and look at the wealth and amount of population that's within that sphere of influence, and whether that overlaps with another operation, and if so, how so, or how much. I'm glad you point out in the case of Philadelphia or some areas of high concentration of population and wealth, those are important factors depending on that factor in to the viability of two operations, let's say. But in our case, we'd have to consider that along with the minimum investment amount. So these are all risks or factors that pull in a couple of different directions. The point is that we would first have to know when two operations two potential operators would have to be. What are they proposing? Are they able to meet the minimum investment required? And does that make them a viable option by virtue of the market and wealth that's within the sphere of influence? Now, when Spectrum did the initial projections to that, for that region, actually for the state, for all three regions, at least for Region C, they picked, just because that was there was no information for them to do otherwise, they picked the geographic center of Region C as any place that a casino could come. That may turn out to be not the case because of all these factors. Indeed, Taunton is not necessarily the geographic center for one, but there's other areas that could be the host of a casino that are also not in the geographic center, but could be elsewhere. So that would have to factor in all of those things.
But when you're talking about the third bullet there, the opportunity cost has to, analysis is, the difficulty of that analysis is compounded by the fact that it is the difference between the commencement of two revenue streams, right? Because if we start now, we're not gonna have a casino there tomorrow. We're gonna have it some years down the road. There's some amount of time that's the fastest something could be up and running. And depending on which of them it is, that time may differ. So the analysis is really got those two variables as components, right?
Very much, and
Yeah.
they are very complicating.
Right.
They are confounding in a way.
Right.
I mean, we could do some of it ourselves, or we could
Right.
have our consultants do some projections and modeling, but ultimately, these are, they inherently contain a lot of variability.
Right.
And we never know the dates, that's the whole problem. If we knew the dates here, this would be a whole lot easier, but
Right.
every date we come up with is
Right.
just a guess. and-
Right. Right.
So, that's the whole problem here. Okay. Any other just sort of background? I mean, that's great. I mean, thank you, both of you, for that. And I think it's really helpful to try to get our arms around it. Is there other just kind of background thoughts that anybody has to contribute to the data collection we've been doing?
I also think this is a really good analysis, and in checking with, because we've had the opportunity to hear from those who are in favor of opening this up and those who are in favor of keeping the exclusivity for the tribe. And in speaking to our consultants, who really do have a lot of information, a lot of knowledge, subject matter expertise, and have reviewed everything that we have seen. Their analysis is that they do not see this happening quickly for the tribe. They do not see a way for this to happen. Their best analysis is years and years away from happening, which is, so they're disagreeing with, of course, the tribe's analysis, which, of course, they're optimistic that they can do it quickly. So, I mean, that was a factor that I thought was important here is the timing factor.
Along those lines, relative to exclusivity, and a point you make, Commissioner, relative as well to the ability of the tribe to pursue a commercial license. They like to correctly point out that they've made some strides with the vote that they have in Taunton, with the ENF certificate and other things under the MIVA process.
They're way ahead of everybody else.
They're way ahead of everybody else. That would, in my view, serve them real well if they were pursuing a commercial license.
Right.
They would, if we decided to open this region, they would be positioned perhaps better than anyone else to do it, by virtue of those things, a host community agreement or something like it. I mean, I know there's differences, but they've made significant strides in that regard compared to anyone else. Unfortunately for them is that there are issues that are significantly important on their land in trust that precede all those efforts, which you correctly point out. But I think it's important to highlight.
Commissioner, you look like you were gonna.
This is, I look at the language, I know we talk about timing, but I look at the language of the statute. The commission determines that the tribe will not have a land taken into trust by the United States Secretary of the Interior. So it has less to do with, we're making a determination on eventuality, or are we making a determination on timing? And as I dug deeper into this, I guess I started looking further into the Indian Gaming Regulatory Act, passed in 1988, which prohibits gaming on lands acquired in trust after the enactment of the bill, except for certain provisions. And just reviewing some of the determinations that I guess it is the BIA made, applications pending for anywhere from 7 to 8 years, applications being denied. I'm wondering if we shouldn't, again, as we look to draw a final conclusion as to whether we ever see this land being taken into trust, whether there shouldn't be, I guess, a thorough review of those applications that went before the BIA and why they were turned down or why they weren't approved. I guess overlaying the IGRA bill over Carcieri, over Patrick, I mean, I guess that's kind of the quandary I find myself weighing.
But that's only operative. That clause is only operative if we are deciding whether by our statute we must issue a commercial process, which we would be compelled to do if we determined that it would never get land in trust, which is an impossibility. I mean,
Right.
there's no way to ever determine that, because any new Congress, new president, new whatever. But that, I don't think that's not, it's not that clause that we're operating under. It's this, that we were left with the right to go ahead with a commercial if we wanted to at any time of our choice. Understanding that there was a legislative predisposition to give the tribe a shot, and understanding that nobody wanted more than one casino. We're not sitting here having to try to figure out whether, an impossibility, which is whether or not the tribe will ever get land in trust. I mean, what we're doing is weighing, weighing incompatible interests without clear guidance from the legislature on what they wanted us to do. As I've been wrestling with this, as I know everybody else has, I've been reading, not to get pretentious about this, but I've been reading Meacham's new autobiography of Thomas Jefferson. And Jefferson had real problems. He was debating whether or not to go to war with Britain in 1807 and 1808. But as he was wrestling about it, he's talking about trying to resolve between irreconcilable and incompatible interests. And he says, "What is good in this case cannot be affected," he wrote Galton. "We therefore have to only find out what will be least bad." And I think that's sort of the situation we're in. The good situation would have been to be able to do what the legislature envisioned, which was get a compact that the legislature could happily approve. It did. Move expeditiously down the road, so southeastern Mass didn't get left far behind. That didn't happen. That was the plan. That's what everybody would have preferred. That would have been, in this definition, in my view, that would have been what was good. Some parties would have been unhappy, but that's what the legislature clearly preferred at the outset. That didn't happen. Now we're trying to figure out what do we make of this, and we're trying to search around for other, for some criteria that make us feel comfortable making a decision where these incompatible interests are going to get resolved. And I see some things which under other circumstances might be a little exogenous, but what I don't think are exogenous as we're wrestling with, what to do here. The operating under if we're going to wait around for the compact, operating under the compact protects surrounding communities significantly less than a commercial application protects surrounding communities. If there's a compact and it's happening, that's the way we're stuck, that we'll deal with that. But that is of value. Surrounding communities are not anywhere near as well protected. Similarly, live entertainment venues are not as well protected. Similarly, and this is an important one, the commission, if it's supervising a compact, has very compromised ability to enforce its judgments. Our first priority is to protect the integrity of the gaming in Massachusetts. That's by law. By mandate, our first statute, our first priority. Under the old compact, we would have had a hard time doing that because we can't say yes or no about anything. We can complain and take it to arbitration, but that is a very compromised way to implement our judgments about protecting the integrity. The new compact, which we were never given an opportunity to look at or to review prior to its being agreed upon, takes it a step further and takes all of the non-gaming activities and venues out of our purview altogether, even though that's lots of times where the troubles are. The laundry provider, this, that, and the other thing. So as I'm sitting here, the compact arrangement is an imperfect arrangement, is a suboptimal arrangement in terms of protecting the public interests. So if we're wrestling with, can we possibly influence which of the two outcomes we select, there is some reason to think, in my view, that the compact is less desirable.
Can I just,
Yeah.
without getting into that analysis, that one of the outcomes is two, right? And the tribe operating under the compact but paying
Right.
zero revenues. So one of the outcomes possibly is a commercial casino plus whatever difficulties you've just
Yeah,
outlined.
I agree with that. But we don't know, we don't know, one of the many things we don't know is if we did do a commercial license, what in fact will happen. We don't
Well,
know.
that's right.
We don't know if
That's
there'll
right.
ever be land in trust.
That's
If
right.
there is land in
That's
trust, will they able to get the financing to do the kind of facility that would really, et cetera.
Right,
So,
all I wanted to do is make sure we understood
Yeah.
it was not either or.
no, I agree with that. I agree with that. It was, as best, again, we have made an effort to try to figure out legislative intent. This is one place where we did want to ask the advice of the legislature because we are trying to figure out what they would want us to do under these circumstances. And to the extent that anybody will talk with us and talk straight, it is, I think, quite clear that the legislature's higher priority as between waiting for a long time or having the possibility downstream of two, waiting for a long time is less desirable. There is little appetite that I can come across, that I can hear about, that has the legislature suggest that they'd like us to wait, and that was the intention. So, I mean, I'll tell you where I come down on this, unless anybody wants to say anything else, something else. The thing that, as I wrestled with this, that ends up being crucial to me is that if we open it up to commercial licenses, one of the options we will continue to consider is the tribal option. It's just as if, in a practical matter, the tribe either can bid commercially if it wants, or if it chooses not to bid commercially, it can just keep going down the land and trust process. If the tribe's assertions about when it's going to get land and trust are true, are accurate, it will happen before we're making a decision on the commercial license. So we would then look at the situation and we will be trying to determine what's in the best economic interest of the Commonwealth. If they got their land in trust, then we will have that as an option. And we might say to the commercial bidders, we're not gonna go commercial bidder, we're gonna go with the tribe. So the tribe doesn't lose the option of us still deciding that's a better way to go by us opening up to the commercial market. And that's just in the nature of things. That's not a conscious decision on our to do a two-track. It's just in the nature of things because they have every right to continue to go ahead and pursue the land in trust. And if it's on the schedule they say it's on, we will know a lot before we make that final licensing decision. So the tribe actually, in this, all these choices are lousy, I agree. But among lousy choices, the tribe has more options than anybody else. They get to bid commercially if they want to. If they bid commercially and lose, they can still do a casino on their own hook if they do get their land in trust. And the best choice of all is that their assertions as to schedule are right, and they put the land in trust option in front of us with a signed approved compact before we make the licensing decisions for the commercial. So as suboptimal as it is, it's less suboptimal than any other choice.
I see it in essentially the same terms, with one clarification. Maybe it's not a clarification, maybe it's the same thing. We've talked before about parallel tracks, i.e. we'd go down the commercial track, we'd go down the tribal track. By the time we're ready to issue a license, we'd look to see where the tribe was. If the tribe had succeeded, we would withdraw the commercial piece. We've talked about how fair that would be to the commercial applicant. We've talked about whether under that kind of a situation, a commercial applicant would bid. We've talked about the equal protection kinds of problems that would remain. It seems to me, though, that if we did what you suggested and said basically that we were going to open it up, but when it came time to do our licensing, commercial licensing, the piece that we have control we were gonna look at this purely as an economic and other decision. So that if the tribe were there and up and running, that did not necessarily mean that we wouldn't issue a commercial license. It would mean that we would require the commercial licensee to demonstrate to us on a business sense that this was a commercially viable venture and take into account the 15 to 17% we could get from the tribe, among other things, before making a judgment. But the judgment would be made on economic and other terms, not on a set-aside terms. And
Exactly.
Yeah, and
And
that, it seems to me, is.
I just want to make one thing, that was actually a click in my brain that I hadn't quite got to. If we go commercial, the tribe is perfectly able to go ahead and do what it's doing right now anyway. And it can come to us at any time with land and trust and a compact and say, we want to go with you. And we will have to make that decision if it comes to us. It's not like us opening up 2 tracks, it's just its own natural process taking place. And we will then be directed by our statute to make the decision which enhances the economic development and revenues and everything else the best for the Commonwealth. You know, so the commercial bidder in Springfield has to bid against 3 other bidders, 3 other commercial bidders. At the moment, there's 1 commercial prospect in southeastern Mass. In effect, they are gonna have to consider the tribe as a potential competition, knowing that it could turn out that the tribe offers a better financial and economic situation for the Commonwealth. So that's no big deal, everybody has competition.
I would agree exactly with those notions. It's a different kind of competition, but what I was terming relative to the financial projections of a commercial bidder and what those projections turn out to be if there's a competing interest, all of that would have to be analyzed on the merits of that proposal, and how we feel they've assessed that risk, and whether they have incorporated it, or simply, before we make the licensing decision, whether there's new information that informs those risks that I keep talking about.
Right.
And that makes our decision to be based on the merits of the financing, for one, among other things.
So let me see if I'm understanding, because I know you're saying something a little bit different. Mr. Chair, what I first heard from you was kind of assess both situations and make a decision. Commissioner McHugh was saying, well, that decision should be made on the best proposal, the economics, but that doesn't.
No, what I'm saying now is, given what I know about, as best I can discern what the legislature wanted, as best I can figure out about all the different competing interests here, it is not a wise choice on our part to wait further for a commercial option for an unknown future on the tribal side. The cost of doing that is a cost too high, in my opinion. What helped me come to that conclusion, however, is realizing that if we go down the commercial route, we're still gonna have the tribe sitting there doing whatever the tribe does. And if it comes to us with a proposition that it can demonstrate is economically attractive to the Commonwealth, maybe more attractive than the option that the commercial bidder has, we can look at that, and we could make that decision.
So we could look at saying, okay, the tribe has made enough progress, or their proposal is such that that's the only, we're going with that option,
Well-
and we're not going to issue a commercial license?
Well, we would be, in my scenario, we would be deciding, yes, we might decide not to issue a
Is that fair to
commercial
say,
license.
here's your $400,000, we're opening up the region, and then get down the road and say, oh, we're not going to issue a commercial license?
I would underscore what Commissioner McHugh was saying. We have control and analysis over the commercial license, unless, of course, the tribe decides to bid commercially. But that aside, if we were to issue an RFP, we give it some time, because that's what our process calls for. Get a proposal back, we analyze that proposal with all of the context around it, taking into place, meaning whether there is more doubt relative to the viability of that license, the commercial license that we issue, by virtue of whatever the tribe may or may have not accomplished between now and then. But we would be analyzing the merits of the proposal for which we control, which is the commercial license.
Yeah, I think that is a difference, Mr. Chairman, between what I said and what Commissioner Zuniga just restated and what you said. That if we, as I view it, if we go down the commercial path, we would take the commercial path to the end.
Yes.
And we would get a commercial proposal or proposals. And we would look at the commercial proposal or proposals and make a judgment, economic and other, based on the facts as they then occurred and appeared at the time, taking into account whether the tribe had its approvals and was likely to succeed, or had progressed it in such a way that we could tell that it was likely to succeed or unlikely to succeed, and then look at the economic and other viability of the commercial.
Track.
No, because the dual track that we were talking about before was a track in which if the tribe got its land in trust, we would say, no matter where we were, we're not going to issue a license. We were gonna proceed down two separate tracks. The tribe would go down its track, we would go down the commercial track. But we would stop the commercial track if the tribe succeeded to a certain level. That's the idea that was initially floated. This is not a dual track in the sense that we could very well have confidence that the tribe was gonna get its casino, and yet the commercial casino was an economically viable entity, notwithstanding the tribe.
Right.
And as you said in Pennsylvania, there may be some synergy there that could be demonstrated, so that the Commonwealth winds up in a better deal, both sides wind up in a better deal.
Well, I'm not sure how the Commonwealth could end up with a better deal if we're getting 0% from the
Well,
tribe.
there would be jobs in construction for that
Well,
operation.
You could also, they would have to make the case that the 25% the commercial casino generated was greater than the 17 or 15% that the tribal casino would have generated had it been there exclusively. And they would have to show that, that by doing market share analysis as well as revenue analysis. Maybe they can't do it, but at least that's an economic judgment rather than a political judgment. if you
Or
will.
set aside.
Yeah, set aside.
I don't mean to complicate things, but
Well, go ahead, you already can.
the
Already
only
covered.
ones that can, in my mind, in my opinion, really have a dual track are the tribe. If we decide to open up for a commercial license that region, they could start to put together a commercial bid and continue with their land in trust
Of course.
process until such time it becomes convenient for them to withdraw or not, or suspend. Withdraw their application if it's with us, or suspend their efforts if they feel they can further continue their commercial license application because they feel good about it. I guess we're now in agreement, but you and I, Commissioner, relative to, from our perspective, if we issue an RFP for that region, we should analyze the proposals that come under that RFP on the merits and on their own merits. Again, taking into account what's around it, but what makes those cash flows confident or viable.
So if proposals came in, commercial proposals, and they didn't demonstrate to our satisfaction that they were more advantageous than what the tribe could offer, then we would not issue a commercial license.
Depending on where the tribe was. Yes, we take into account where the tribe was, what we were reasonably certain the tribe's prospects were as it then appeared, what the value we would get from a commercial casino given what we knew about where the tribe was at that time? And does that value from a commercial casino outweigh what we think we can get from the tribe when it comes? It's a competition of a different kind, is what we're talking about.
And given what we've heard from the one bidder that's in the market, the one bidder that's in the market has repeatedly said to us, we don't care what's going on with the tribe, just, we want to go forward, we don't care whether it's another casino, it's not a problem. That's what they've been saying. So this will, this will flesh out what the market will really bear. The question you were originally saying, can they see an ROI that has a minimum 500 million plus an $85 million licensing fee? This will flesh out whether this is for real. And is there anybody else besides KG that's interested? But also, I don't see it as different in kind, really, in any fundamental way, especially given what they're saying so far, from the competition that everybody else is going through. You know, I don't see why this is any different from the people in Springfield, or in Western Mass, where they have at best a 25% chance of winning. And
Well,
we're gonna make the decision
we
based
are-
on an economic analysis of what's best for the
Correct,
Commonwealth.
but we are most assuredly, or unless they're all very poor quality bids, we are going to issue a commercial license. There is no certainty of that.
Well, we're gonna issue a license.
Well, a
Yeah.
commercial
Yes,
license.
yes,
In the other
Western-
regions.
in
Yes,
Yes, right.
but there's no certainty of that with this plan that
Well-
you're proposing.
Technically, we don't have to issue a license in any region unless we're convinced that they bring an economic benefit to the Commonwealth. I think it's under the same general principle that for Region C, with a very different flavor of competition, we'd be analyzing it.
It is a different flavor of competition, but it's not one that has any non-competitive elements to it. In other words, there's no disappearing eligibility automatically disappearing eligibility based on what the tribe does.
Right.
The tribe, commercial person goes through, they have to demonstrate what they're gonna do vis-à-vis Twin Rivers, that they're viable vis-à-vis whatever Twin Rivers turns out to be, whatever
Yep.
turns out to be what the tribe does, what happens in Region A, and where a slots parlor is. I mean, there's a lot of variables and that's just one more variable than exists in other regions, but the analysis is the same in all regions.
Right. We're gonna make a decision based on which bidder offers us the best economic value,
Right.
basically.
Right.
And that's gonna be that would be true in Region C as well as in Region A and B. The exact same criteria are gonna be at play. What is the best long-term economic deal for the Commonwealth?
And among those is how viable a commercial license with the prospect of competition from the tribe
From an untaxed.
has, and how sustainable that is, and for how long. It's not at just one point in time. We have to be convinced that even with competition, by virtue of the tribe potentially pursuing Class II gaming on their own, what would that do to that license, the Region C license, commercial license?
Right. You were thinking about maybe getting some more information here. Where are you at this point about?
Yeah, I'm just sitting and thinking back about benefits for the tribe and kind of a revised dual tracks.
One thing we could do, Mr. Chairman, and we've been talking about this for a long time, as we should. This is a big deal, and we need to decide if we need to move forward. But one step might be to coalesce, to the extent we can, around a target solution and give everybody one more chance to comment on that target solution for, say, a couple of weeks, and then come back and make the decision, to make sure we haven't overlooked something. Make sure that everybody has a chance to give us a final comment. They may say just what they've said before, but much as I believe that the solution we've been talking about is the right solution, that might be a good way to proceed. Simply look at those comments and then make a decision if we haven't overlooked something.
I think my, given how long it's been,
Right.
given how much comment we've had, I think my preference would be to structure it a little bit differently. To if we indeed do support this approach, do a presumptive step in that direction. Then put out some assignments. We got to think about how this would work operationally. What would we do next? And invite comments on that presumptive vote. And if something comes up that makes us want to rethink it, we could rethink it. But
I don't think we're saying different
Yeah,
things.
okay. I hate the idea of, yeah, okay.
Just not take a final vote today. Coalesce around some plan. Draft the mechanics of that plan. Come back and consider whatever comments we've received and then implement the plan. Or not, if we've overlooked something. Is that what you were saying?
Not quite. It's a little bit, I mean, it's partly semantic, but I think people, I think there's a sense that it's decision time, and I think it's decision time too. And we have really gone head over heels to give everybody a chance to give us their say-so, and to have us say, we'll make a final decision in a week or two. It just, I guess what I would say, I would like to have a vote, I think. I'd like to have a vote that creates a clear presumption that we're on a certain road. And as we then step off to flesh that out, if something comes out of the woodwork that we've totally missed, then of course we would reconsider that. But I think, for what it's worth, I would prefer to make a decision.
I would agree with that. I think it's incumbent upon us and our public and our constituents to make a decision. There's a lot of time that passes between deciding to issue an RFP and eventually licensing. I don't want to get caught up into the dual track. I think what we talked about is I think it's fundamentally understood, but I think it's decision time.
Well, I think I know what I think is the right decision, so I'm prepared to do that. I sense that.
Just a little bit of the way it's, I think everybody would agree with you that if something comes out of the woodwork that we hadn't anticipated, we would think about that. I think the way we structure the way we frame, the way we phrase what the action we take today is the way what we're concerned about.
We have not, this particular plan has not been out there, correct? No one has commented on this particular path forward.
Well,
I would argue that they have.
I agree.
Well, we got the negatives about a dual track, but what we're offering now, what this is now is different than what was spoken about before.
No, we'd be issuing an RFP for, if the majority approves that. Of course, that could be defeated, and then we wait. But we'd be issuing an RFP for Region C.
But with the difference that to me, it's not the same as an RFP for Region C, because there are different circumstances. There's a piece here that commercial license may never be awarded. So I do see it as different.
Just like any other license will not be awarded if it's not viable.
There is a distinction. There is a distinction.
All I'm saying is, I think what we've been discussing is If and when we get a commercial bidder, if we issue the RFP, if and when we get a response, that response is going to be analyzed on its own merits, subject to the financial suitability. And that financial wherewithal would have to, by necessity, take into account how real or is a tribal operation, however far from where they propose. And if that's taken into account properly, with some degree of confidence, we have to see if it meets the minimum investment requirement, if it's beneficial to the Commonwealth, and then make a decision on awarding of a license or not.
It's clearly we're using different words, there's no question about that. I think what dawned on me was this is not an action that we are taking, this is an action that is there. If we go down the commercial path, anybody who's really thinking clearly about this realizes that at any point in time, the tribe might get land in trust and maybe have a signed compact and be ready to present an alternative. It's not within our control, so if anybody's been thinking about this carefully, they would realize that this has always been an option if we go down the commercial route. So in that sense, it's nothing new for people to think about if they've really been paying attention. But I understand what you're saying, and we're framing it a little differently. Okay, where are we?
Well,
I'll tell you,
I'm sorry.
I was comfortable with really trying to get some comments, because I think there could be things that we're not thinking about here. This is the first time that I've heard this plan, and, I had a different opinion about the dual track, which I do see as I see the distinction. But this particular plan, I don't think anyone necessarily would have thought about. I don't think that people would have seen this clearly by imagining, okay, commercial, but then we're going to assess and see where the tribe is and look at all the economics. I don't think anyone would have necessarily thought through all of those ramifications. So I was comfortable when you, Commissioner McHugh, said, look, we could ask for comments for a week or two. And I do understand that we don't want to drag this out, and it is important that the region does not fall behind. So I do understand that sense of urgency. But I do think this is something, I'm trying to think of in this, how long have we been talking about this, for an hour? I'm trying to think of all of the possibilities around this new scenario that I'm hearing for the first time.
I would really like, as we all would, everybody to be comfortable with this, and
Everybody meaning?
well, the five of us.
The five of us, okay.
Yeah. And I think we all would. And I really don't, I understand the desirability of stopping talking and doing something. But I don't think 2 weeks is gonna make that big a difference if it could raise the universal comfort level around this table. And so I reiterate the desirability of doing that. I'm prepared, I will tell you plainly, I'm prepared to vote yea today, but I do not think on what we've talked about. And it will take some powerful comments to change my mind. I think this is the right way to go. I've thought about it, talked about it, listened to it. But I think it's very important for the decision to be unanimous if it can be, let me put it that way.
Do you have a sense just on this issue about whether to vote or not?
I guess I join with Commissioner Cameron and the judge's original notion of laying out this scenario for comment, because I think it is different than anything we've talked about before. I fully subscribe to deciding one way or the other how we're going to proceed. We don't want to leave Region C behind.
Well, if, whether in that case, I mean, for sure, it might be that if we had a vote to do that, it wouldn't go forward, so, but even without that, I think, I mean, the two certain, we would rather let this think a little bit, plus at least a partial also, you know, I think, for better or worse, we should wait a couple weeks.
I would like to say that, I'm sorry, I didn't mean to cut you.
Please.
I would like to say, not we're gonna wait a couple of weeks, I'd like to frame a target in the terms that we talked today. And in essence say, we will receive comments on why we should not do X. And spell out what X is, so that everybody has a firm target about which to comment, and so that all of us understand what the comments are aimed at, and have a proposal on the table. So in that sense, we're advanced, and we either come back in 2 weeks and say, we're gonna go forward with that target, we're gonna make slight modifications, or somebody's told us something that changes our mind.
Well, that's actually helpful, I think, you know, that, you know, so if we, do we do by consensus, just by consensus of the group, that there is a pretty broad consensus that this plan is the right way to go, but because this is the first time it's really been considered in detail, we want to give a last couple of weeks opportunity for people to comment, make sure that there are no points that we're missing, and unless we hear that there are some points that we were missing, we would then confirm that in 2 weeks.
Yeah, that's the way I'd like to frame it.
I may not be joining the consensus only because I don't think it's a new plan. I think, like you stated earlier, it was always
Excuse me, the consensus was that this is the right way to go.
That's right.
Not a consensus,
No,
this
no.
is a new plan.
I know. I won't be joining the first consensus because I think this is not a new plan. The plan to bid Region C, or rather, the option to bid Region C always carried with it the risk of the Mashpees eventually obtaining land into trust and being able to conduct Class II gaming by their own right in that region. The compact contemplates that. It was affirmed twice. I think it's not a new option. I think if we were, it's important for us to clarify it and for everybody to be comfortable with it, and I agree with that. But I just want to state perhaps now 3 times that I don't think it's a new plan.
Yeah.
But again,
I don't disagree, and I don't like, you know, I'm not crazy about 2 weeks for everybody to get all ginned up, and you can imagine the firestorm that's gonna,
Right,
you know, we're gonna have
I know,
a
I know.
tsunami coming down on us for 2 weeks. But such is life, and I defer to the
majority,
concern.
I guess.
Well, even if it's not a majority, I mean, if there are 2 strong feelings that this is almost for sure the right way to go, but we need another little bit of time to think about it, and I think even if it were just 2, I would defer to that, so, you know, so.
I'm a little bit in disagreement of, this isn't a new approach, because as we've been talking about and explaining it, there is an evolution relatively new at the end of this path, that before we award a commercial license, we would look at the status of the tribes.
No, we would not. We would look at the status of that bid, the bid of the commercial license, and how reliable the financing of that bid is in the context of what's around it. I'm sorry, I interrupted you, Commissioner.
No.
But I think that's the key of the difference, which we're not gonna then look at what's going on with the Mashpees and say, do you need us to wait some more or anything like that? We're gonna get confident or not that license is reliable, viable.
And the best way to go.
And the best way to go. It's the case for any other region. For region A or B, we may end up, whether it's 4 or that gets narrowed down to 3 or whatever the case may be, we have to fundamentally be convinced that that proposal is viable. Not just because it's the highest bid, but because they have a plan, they have a strategy, and they have done any number of other things that makes that project viable. I think it's the same analysis over here with a different flavor of competition, but that competition was always there. That the Mashpees could eventually, one day in the future, we don't know when, and I guess that's the crux of it, obtain land into trust and conduct Class II gaming. And I think you alluded to this earlier. That option is 2 casinos in that region. That's effectively what we're talking about. Whether the license that we would be awarding in that region is viable with the eventual presence of a second casino. It's not as if we would then say, no, we only wanted 1 casino, and now we're gonna go over here. I think that's fundamentally different.
I totally agree with you, but not everybody does.
I don't see it as the same as the other regions.
All right.
So should we do something like agree that we will ask for public comment for the next 2 weeks on why we should or should not open Region C to commercial RFPs, with the commission taking into account in deciding whether to issue a commercial license to an applicant, the economic and other circumstances as they exist at the time of the licensing decision, in light of the statutory objectives that govern expanded gaming in the Commonwealth.
Yes.
I think that's well phrased.
Okay, so we just leave that as a sense of it.
Hang on.
Yeah.
I mean, is there any reason why we shouldn't do that? Why we should?
Yes, but.
Yes.
Yes.
Do we agree that we should do that?
I'd be voting no on that, but that's just for the record.
Right. So I think we're,
Yeah.
we're having a sense that, yes, that is what we're
Okay,
going to do.
so that is the question that we will put up on the website, and we will invite comments at MGC Gaming in the normal fashion, with whatever we want to put in the subject line, to get those into the right pocket, and we can review them and revisit this in 2 weeks.
And in the meantime, I think in the interest of time, we ought to be thinking about, if we do down this road, which all of us, I think is a good idea, and unless something dramatic happens, we will be pursuing. For that reason, we ought to start thinking about the process
Right.
ASAP.
Right.
Since the whole idea is not to fall further behind.
Right, right.
Okay.
Yeah, and we could come back in 2 weeks with, assuming, with a contingent process to
Right.
vote on that day. So to get this moving forward, if that's the direction in which we go.
Okay. Anybody else got anything to talk about? Long day's work.
Long day.
Do I have a motion?
Move to adjourn.
All in favor?
Aye.
Meeting is adjourned.